I want to welcome you to the 7th Annual David Aldrich Nelson Lecture in Constitutional Jurisprudence. It's held every year on Constitution Day, September 17th. The lecture honors Judge David Aldrich Nelson, who is a charter member of the Alexander Hamilton Institute's Board of Directors and who served for more than 2 decades on the United States Court of Appeals for the 6th Circuit. Our event tonight is sponsored by the Alexander Hamilton Institute and co-sponsored by our very own Center for Statesmanship, Law, and Liberty here at RIT, along with the Political Science Department. I would like to thank Bob Paquette, the director of the Alexander Hamilton Institute, for his generous support, my dean, Jamie Weinbrink, my chairman, Sean Sutton, for his continued support. We will continue our Constitution Day events with a lecture tomorrow on virtue, statesmanship, and the Constitution from the same speaker, Bruce Fronin, whom I will introduce in a moment. Tomorrow's lecture will be at 4 o'clock in the Skelny Room of the Schmidt Interfaith Center. But tonight, our theme is religious liberty. After traveling to America in 1831, Alexis de Tocqueville, French foreign observer, observed in his great work, Democracy in America, a work aptly described as once the best book on America and democracy, that it was, quote, the religious aspect of the country that first struck his eye, unquote. He noted that the greatest part of English America, he referred to America as Anglo-America or English America, Tocqueville noted, has been peopled by men who, after having escaped the authority of the Pope, did not submit to any religious supremacy. They therefore brought to the New World a Christianity that I cannot depict better than to call it democratic and republican, unquote. The religious foundations of America's origins are well known. The Puritans in Massachusetts Bay, continuing the Protestant Reformation in the New World, strove to build a city upon a hill, an enduring symbol of our self-understanding. The Pilgrims in Plymouth Rock, a more radical Puritan sect, established the Mayflower Compact, the first written constitution in the New World based on consent. Pennsylvania was a self-described holy experiment, started by the Quakers. Rhode Island, once referred to as the sewer of New England, was an experiment in the separation of church and state. The phrase later used by Jefferson, separation of church and state, was coined by Roger Williams, the founder of the colony of Rhode Island. Maryland was a Catholic haven, which passed a Toleration Act as early as 1649 that included the phrase, the free exercise of religion. We may all be familiar with Benjamin Franklin's proposal for a civil religion that would strengthen the country's political institutions in his autobiography. America became a refuge and a haven for those seeking to practice their religious liberty. Religious diversity, at least amongst Christian sects, was a fact, a notable feature of the colonies, and quite an achievement given the wars of religion that had devastated Europe a century before. The unifying experience of the Great Awakening prepared Americans for the Revolution. Yet America was also profoundly influenced by a more secular strand of Enlightenment rationalism. Jefferson, for example, was a severe critic of sectarianism, of religious bigotry, and intolerance. He and James Madison famously led the fight to disestablish the Episcopal Church in Virginia and to defeat attacks for the non-denominational support of religion. Jefferson, of course, in his famous letter to the Danbury Baptists, describes the Constitution as erecting a wall of separation between church and state. While the Declaration, the foundation of the American experiment, I would argue, makes 4 references to the divinity, the Constitution never mentions God or religion except in prohibiting religious tests. Then again, the Bill of Rights, first 10 amendments to the Constitution, includes religion as its first freedom, the first freedom of the First Amendment. There are 2 notable clauses that that relate to religious liberty that we will discuss tonight: the Non-Establishment Clause and the Free Exercise Clause. Indeed, there's a tension between these two provisions. Perhaps this tension has been vital to American liberty, one could make the argument. If construed broadly, the Non-Establishment Clause, in banning religion from the public square, might infringe upon the free exercise guarantee and vice versa. That is to say, the granting of an exemption for the sake of conscience, the free exercise of religion, may in effect constitute the preference of one religion over another, thereby undermining the very equality that the Establishment Clause promises to uphold. Interestingly enough, the same Congress that passed the First Amendment also approved of Washington's request for a national day of prayer and thanksgiving. So we gather here tonight on Constitution Day to reflect upon the legacy of religious liberty, the first liberty of our Bill of Rights. Our keynote, Bruce Fronin, will provide a historical overview of the struggle for religious liberty in America and a consideration of some of the core principles of religious liberty. After his presentation, we will analyze briefly the Supreme Court's application, or lack thereof, of these principles in two recent cases: Burwell versus Hobby Lobby and the Town of Greece versus Galloway, a case right from our own backyard. We will conclude with a question and answer session, so please hold all your questions to the end, and the panelists will do their best to answer them. In the 21st century, our century, religious bigotry, intolerance, and persecution have far from vanished. Consider the recent genocide campaign against Middle Eastern Christians, the resurgence of anti-Semitism in Europe, and the sectarian strife between Sunni and Shiite Muslims. America remains a haven. America remains a haven. And can America still be considered the land of the free in this regard? Are the Constitution and the Bill of Rights fitted for an increasingly multicultural and secular nation? Now I'd like to introduce our keynote speaker. Dr. Bruce Fronin has served as a visiting scholar with the Johns Hopkins School of Advanced International Studies. He was the Charles Evans Hughes Professor of Jurisprudence at Colgate University last year. He was a legislative aide to United States Senator Spencer Abraham from Michigan and is senior fellow at the Liberty Fund. Bruce is a prolific author. He has edited or authored 14 books. Two of his volumes, The American Nation, Primary Sources, and Rethinking Rights, were named outstanding academic titles by Choice. His articles have appeared in journals including the George Washington Law Review, the Harvard Journal of Law and Public Policy, and the American Journal of Jurisprudence. His research interests focus on religion in American public life, the nature, development, and prospects for constitutionalism and human rights. He holds a JD from Emory University School of Law and a PhD in government from Cornell University. He is currently teaching at Ohio Northern University Law School. His most recent book, Constitutional Morality, Structure, Norms, and the Rule of Law, will be released next year by Harvard University Press. Please welcome Bruce Fronin.
Thanks so much, Joe. Thank you for that kind introduction and for all the work that I know you, RIT, and the Center for the Study of Statesmanship have done. Thank you for bringing me here. Thanks also to Bob Paquette and the Alexander Hamilton Institute. I greatly appreciate and am honored by presenting the lecture co-sponsored by the Institute. Thank you all for being here. We need to talk today a little bit about religious freedom in the Constitution. And I hope that we'll remember that what we are talking about, in part at least, is religion, which is to say, a social practice, not just free exercise by individuals, not just the lack of establishment by the government, but the practice by groups of like-minded persons of worship and ways of life. It's this understanding that I think is necessary in order to understand what lies behind more recent Supreme Court decisions and actions in our broader culture, which seem much more, since the era after World War II, seem much more to be concerned with the relationship between the federal government and each of us as individuals, either limiting us in our activities so that they don't harm others, or protecting us as individuals from potential tyranny from localities, states, and various social groupings, including religion. It is an interesting turn to a long tradition in which our pluralistic society has been seen as being made up by not just individuals, but the fundamental constitutive groups that individuals form and are born into, and in which they live the bulk of their lives. I want to just briefly mention one of the many issues that Professor Fornieri mentioned at the beginning during his introduction. He talked about the Declaration of Independence, which I know he considers foundational and of extreme importance, that document makes of the deity, in contrast to the lack of such mentions in the United States federal Constitution. And I think it is, in fact, a highly interesting and useful contrast to draw. And it points out something that I think is far too often overlooked in discussions of our Constitution more generally, but in particular in relation to things like religious freedom. Namely, that there was a distinction which the founders of our country recognized, which, for a variety of reasons, is no longer generally recognized, between those 13 independent states declared independent by that first document, which were seen as natural, organic, historically rooted focuses of attention and loyalty in which people lived, and the more distant, more artificial, more mechanical, hence more limited governments at the federal level, which was intended from its beginning to have a much smaller impact on the lives that Americans would lead. Now, in discussing this set of issues, I'd like to go back to the beginning, or at least as close to the beginning as makes sense in the American context. So, in the name of God, amen. No, I'm not about to give you a sermon. I may be accused of preaching, particularly by my children, but that's not my purpose here. That is, in fact, a quotation. It is the beginning of the beginning in some ways, because it is the opening line from the Mayflower Compact. The first line of the first constitutional document applied to the English settlers in North America. In fact, the Mayflower Compact carried on a long tradition, going back some 100 years in the mother country, where the Calvinist dissenters forged church covenants, they were called. Later they became constitutional documents, in which they would pledge to one another to walk in the ways of their Lord together, in order to form communities that could survive the intolerance of the Anglican establishment in Britain. They forged these communities by which they would elect their own ministers, by which they would regulate their own conduct among one another in religion, but also in economics and in social life, so that they could flourish as a group worshiping God in the way that they chose, but also leading the kinds of lives that they wanted to, and flourishing as a community. That document, the Mayflower Compact, by which the Puritans formed a colony in the New World, continues that those who signed the document, quoting, "having undertaken for the glory of God and advancement of the Christian faith and honor of our king and country, are now forming a new colony, and we do," quoting, "solemnly and mutually, in the presence of God and of one another, covenant and combine ourselves together into a civil body politic for our better ordering and preservation and furtherance of these ends. And by virtue thereof do enact, constitute, and frame such just and equal laws, ordinances, acts, constitutions, and offices from time to time as shall be thought most meet and convenient for the general good of the colony, unto which we promise all due submission and obedience." So what we have here, then, again, what can well be said to be the first constitution of the English settlers. There had been company charters before this. There were also, in Virginia, martial laws. Yes, he said martial, as in military, as in lots of death penalties. Jamestown was run on a somewhat different model. The settlers were there for financial reasons, and they weren't behaving well. So they ended up being ruled according to martial law for quite some time. But it was this, the Mayflower Compact, that brought to the continent the constitutional tradition that had, in fact, developed in Great Britain. As a constitution, the Mayflower Compact bound the Puritan colonists to work for the common good and to abide by the laws which were enacted by the government that was thereby established. As a religious compact, which it also was, that document bound its people together as a people in the name of God. So we have then with the Puritans a very self-consciously religious community using all the forms of constitutional government with the purpose of founding a society that would be ruled according to law, but that had as a necessary witness and party to the contract, God. All right. Let us then fast forward a bit to the era of the American Revolution, in which the colonists were fighting for independence from Great Britain. We know that a constitution for these United States came out only after that revolution had been completed. But before the national constitution was drafted, there was another conflict. There were, in fact, many conflicts. But the one I'm thinking about is the one in Virginia. The newly independent state there was considering a law that would tax all Virginians in order to pay Anglican, and only Anglican, teachers of religion for the state. Now, in petitioning the Assembly to reject this legislation, James Madison, who some of you may know as the father of the Constitution, laid out his reasons for opposing this law, for delivering this memorial and remonstrance against religious assessments. He argued that, quoting, "Religion, or the duty which we owe to our Creator and the manner of discharging it, can be directed only by reason and conviction. That is, not by force or violence. The religion, then, of every man," Madison said, "must be left to the conviction and conscience of every man." Individualism here, every man. "And it is the right of every man to exercise it as these," that is, conscience and conviction, "may dictate." So, religion, Madison was saying, is a matter of conscience and personal belief. It is, in this view, a fundamentally individual practice. It cannot be directed by force, only by reason, aimed again at particular individuals. So it's wrong, ineffective, and an insult to our Creator, in Madison's view, to use the state to force people to promote something in which they do not, in fact, believe. These, then, are two poles between which religious debates in the United States can be seen as radiating for most of our history. On the one side, those who insist that religion is the basis of that society, its very purpose for being. That we become part of a society, first and foremost, by sharing the commitment to a particular way of life, and a way of life rooted in religious belief and practice. The individualism of Madison, no doubt more appealing to college students such as yourselves, was in stark contrast to the community-centered views of religious groups active during the formative years of the Republic. But still, there is in Madison's Memorial and Remonstrance a clear reference and emphasis upon the duty each of us owe to God. That is a specific deity. And both coexisted for many decades, before the War for Independence and after the formation of the Republic. How did this happen? How is this, in fact, possible? We may begin with the words of the Constitution, or at least the Bill of Rights, in regard to religion. They're brief and found in the First Amendment. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. We can be pretty sure what these words meant at the time the Bill of Rights was appended to the Constitution. What does it mean for Congress to make no law respecting an establishment of religion? It means that Congress shall neither establish nor disestablish any religion. It's important to keep in mind here that a number of states, 7 is probably the most accurate number, had established religions at the time of the founding and for decades thereafter. Massachusetts, for example, had an established religion well into the 1830s. 1833 is usually given as the date of disestablishment. That is close to half a century after the Constitution came into existence. What we had then was a split in terms of the views of what the government was to do in regard to religion. There was one standard for the states and a different standard for the federal government. The states were, again, organic, natural forms of government in which people lived the vast bulk of their lives. They were in charge of safety, health, the welfare of their citizens. They were considered to have the legitimacy to pass upon, to enact, and to deal with fundamental social, political, economic, and religious issues. Issues on which communities were deemed to be competent to decide for themselves as communities. The federal government, on the other hand, was an artificial construct established for very specific and limited reasons. The federal government became necessary because under the Articles of Confederation, the states found that they were a feckless and embarrassed group of states. They had no respect on the international stage. They needed help in terms of foreign policy, in terms of defense, and they also needed to establish a common market of sorts among the states, to end the taxing of goods from one state traveling into another, and to establish certain fundamental institutions, post roads, for example, necessary for the country to function as a single economy. This kind of construct, even though in a number of ways it would act directly on citizens, lacked the purpose and it lacked the legitimacy to determine for a community so vast and so spread out, yes, so pluralistic, but also simply so spread out, as a relatively unpopulated nation in a time of horses and buggies was. It lacked the legitimacy and the means to act as a single community, legislating on fundamental issues of the social makeup of the people. So, one thing we know about the Establishment Clause is that it was aimed specifically at preventing interference from the federal government in what was going on at the state. But another question which arises at this point is just what is it we mean by establishment? And I think it's necessary for us to talk about this because this federal structure would end up being severely undermined, if not done away with, by the middle of the 20th century. So what does it mean to have an established religion? Well, the prime example, the paradigmatic example here, because it is the source of, well, America, would be Britain. And in England, the established church was truly established. The monarch was not only the secular ruler, but also the ruler of the church. Those in high office and many in no office at all had to declare, they had to swear an oath of loyalty to the king, not merely as king, but as head of the church. The monarchy was responsible for appointing, potentially dismissing, and controlling high religious officers, bishops. It controlled the liturgy. It made pronouncements through the pulpit. The church was to maintain records, birth records, baptismal records, marriage records, on behalf of the state. Taxes were collected from everyone in order to fund the one church, and only the one church. One was to make regular attendance in the one church, on pain of fines, potentially very heavy fines, non-payment of which could land you in jail. Oh yes, and if you were a Catholic or a Jew, you couldn't worship. Public worship in either of these religions was illegal. In point of fact, a number of priests were executed for fomenting what was considered to be treason. So what you have then in the British example, and many of these provisions lasted well into the 19th century, what you had in the British example was a clear establishment of a religion. Okay? Intermingling of secular and religious government, intended to make sure that people belonged to and supported the one official religion. Things were a little different in America, even before the Revolution. All right? Now, you did have in some of the southern colonies a kind of Anglican establishment. It was, however, much weaker, in part because people were just too spread out, and in part because people just wouldn't put up with as much from their government. You did nonetheless have, for a time, established religions in various colonies. One of the great fears that spurred the American Revolution was that England might actually send over a bishop, an appointee of the crown who would serve to instill discipline in these undisciplined Americans. So it was sort of established, but let's just say not to the English extent. And this was only in the South, and the Anglican Church, after the Revolution, when it became the Episcopalian Church, lost most of its public legitimacy. Most Anglican priests were Tories, that is to say, they opposed the war for independence. So it was not long after independence that the Anglican Church, the Episcopalian Church, lost its primary support from various state governments. There was, however, another model, among many. An important New England model is presented by Massachusetts, in many ways the most American model, in that it was highly localist. If you lived in Massachusetts, the rule was, and it was a state rule, statutory rule, legal rule, find your own preacher. In essence, Because the rule was you had to find a minister as a community, pay and support that minister, and the teaching of your children. It would include the religious teaching. The point was communities, townships, villages chose, in essence, their own religion to establish. So you had established religions in the various local communities. Now, most of them were Congregationalist, which is, the Puritan religion, but not all of them. There were some Unitarians, some Presbyterians, and things such as that. There was a state and established religion that used public funds to support specifically religious activities, and it was limited to a church, although in this case, it was limited to a church determined by the locality. You also had a number of other practices, such as a requirement that those who sought to serve in some public office, sometimes only elective office, sometimes something as basic as on a jury, would have to make some sort of religious oath. This was, in fact, one of the things that the federal Constitution, not in his Bill of Rights, but in the actual original document, said we're not going to do at the federal level anymore. Because at the federal level, we, being a more limited, distant government, aren't going to depend on these things. But at the state level, in most of the states, there was a requirement that you subscribe to some set of religious beliefs, anywhere from a very basic, vague deism in that Quaker land of Pennsylvania to fairly specific provisions in some of the other states. So, establishment really could have teeth, potentially painful teeth. But in the United States, it tended to be a less strict form of establishment, certainly than one would find in Europe. In Massachusetts, for the most part, what meant was that citizens had to come up with some religion for their community, and if you didn't choose, well, then the Congregationalists get it. What there was in general, almost nationally, was a kind of generalized support of Protestantism. The point then is that the Constitution decreed that the federal government mind its own business on issues of religion. States were to be left free as self-governing, semi-sovereign communities to regulate religion in the manner they deemed best. And everything from overt support for one specific religion to general accommodation of Christianity, or more general theism, to complete neutrality between religion and non-religion, all of this was to be allowed because it was none of the federal government's business. Period. Individual dissent would be tolerated more or less depending on where you were. Thus, if one was too much of a dissenter, one would in fact have to follow Roger Williams and vote with your feet. You could always go to Rhode Island, that sewer of New England. Okay. Obviously now things have changed just a little bit since this time. But why, how, and to what extent? To what effect? I want to just briefly, and in a very skeletal fashion, talk about some of this. The why really is the most interesting, or at least the most overlooked and misunderstood element here. The United States moved away from the localist tradition regarding religious establishment, religious freedom, largely out of a concern to protect American public education. Public schooling is at the center of religious freedom issues in the United States. It is today, one still hears about public school prayers, and it was during the early 19th century. American public education, a significant number of people decided, needed to be protected from outside forces. What were those outside forces? Irish Catholics. In his important book, Separation of Church and State, Philip Hamburger, who is Jewish, if that means anything to you, shows how conflicts over public funding for religious schools led to a massive shift in arguments regarding the Constitution and religious establishment. All this took place beginning in the 1830s, which was not coincidentally an era in which Enlightenment ideas had gained some foothold at the state as well as the national level, but it was also during the beginning of the wave of Irish immigration. In essence, what happened was that the Protestants, shocked that Irish Catholics were succeeding in gaining local public funding for Catholic schools, began arguing that the Constitution forbids that kind of support. One must keep in mind that the state-run school is a relatively new development in America, that for most of our history, schools were run at the very local level, and that even in places like New York City, New York was one of the focal points of this struggle, what you had was a state which would hand over money to local organizations to run the schools as they saw fit. So this was a very local set of issues. It was ironic, in fact, that these particular Protestants chose to take offense at the Catholic inroads because public schools, since before the beginning of the Republic, and right up through this time, and well into the 20th century, required readings from the King James Bible on a daily basis, and discussions thereof quite often. But the Protestant activists argued, Protestantism is not an established religion. By nature, it cannot be, because Protestantism has no pope, no hierarchy, no foreign prince. Therefore, it's okay for schools to support the Protestant religion because it's a religion of many different sects and no particular doctrine. Proponents of this separation of church and state put forth a constitutional amendment to ban the use of public funds for sectarian, meaning Catholic schools. By now, we are in the late 19th century. A little thing called the Civil War set back some of these issues. But by the late 19th century, we had a movement toward what were called Blaine Amendments. The Blaine Amendment failed at the federal level, but it was written into a number of state constitutions. These amendments sought to change that constitution to bar support for any particular disfavored religion, maintaining it for a general Protestantism. The one was not good, the other was traditional, established, and to be continued. Obviously, though, that's not how things worked out, now is it? This was an attempt, and it helped with the growth of the demand that there be separation. What did happen then? Well into the 20th century, most states operated under a theory best described as accommodation of religion. That is, while the federal government stayed out of religion, states saw themselves as abiding by a kind of Madisonian respect for individual conscience by accommodating it in particular circumstances. The best examples I can give you are the lack of test oaths for public office and the fact that Quakers didn't have to fight in wars because it was against their religion. This accommodationism did not extend to banning long-standing practices like a local town's nativity plays or prayers before the opening of various public events. But the dominant view on the Supreme Court since 1947 has been something quite different. What has been called separationism, one scholar has called it disestablishment. He even refers to it as the disestablishment clause, as in separation of church and state. Of course, the phrase itself appears nowhere in the Constitution. As Professor Fornieri pointed out, the wall of separation between church and state appears in the writings of Roger Williams, a prominent religious dissenter from the 17th century. It also appears in a letter from Thomas Jefferson to the Danbury Baptist Church. This letter, which was used by Jefferson in his fight, in particular with New England clergy during the election of 1800, was a declaration on Jefferson's part that the federal government should not be seen as being involved with religion in one way or another. Jefferson's own career is illuminating here. After he was elected president, Jefferson refused to follow Washington and Adams in declaring things like days of fasting and days of Thanksgiving. This was in contradistinction to his practice when he was governor of Virginia, when he not only announced such days, but he announced such days along with penalties for ministers who refused to do as they were bid, that is, to call the congregations together. Okay. So what really changed? How did we come from a time when religious freedom meant localism, local rules, to a time when today we have a movement toward disestablishment? A couple of things happened. Most importantly, but preceding some of what we're talking about, was a case in 1940, Cantwell against Connecticut. This was a Supreme Court decision in which the federal government first chose to begin protecting free exercise of religion on the part of individuals from states and localities. We begin to see the federal government intervene between individuals and their local, state, more organic governments. Here we had a town that said that those who were going to solicit from door to door had to come in and register. The town wanted to make sure that there was no fraud going on, that people weren't thieves or any such thing, so you had to come in and register. You had a couple of Jehovah's Witnesses who said it was, in fact, against their religion to come and register with the state. Why would I have to register with the state in order to proselytize? The court here found that this was too much of a burden on the religious free exercise of these Jehovah's Witnesses, so it struck down this rule. Well, how did it strike down this rule? I thought there was a separation between what the federal government could do and the state and local government. A doctrine called incorporation, by which the Supreme Court argues that the rights spelled out in the Bill of Rights, more or less, shall be applied to state and local governments on account of the 14th Amendment. This was an amendment passed, brought into law in the aftermath of the Civil War, intended to protect freed slaves from potentially murderous mobs and from laws specifically aimed at disenfranchising them and keeping them from things like access to courts. Incorporation has become the law of the land. There's a primary importance to what's happening. The state now intervenes. The second thing that happened, in Everson against the Board of Education, it was decided by the Supreme Court, in fact, that it was okay for a local school board to pay for religious kids to go to religious schools, that is, pay for their bus fare. Because it was argued, well, look, everybody has to take a bus, and we would actually be putting a burden on religion if we didn't do this. So since everyone's getting the same benefit here, let's let them have it. What was most important about Everson was that it included within itself, for the first time as an active, important part of the decision, the metaphor of separation of church and state. And while this case came out for the religious group, the next case, and pretty much every case after that, went the other way. It was found, for example, that you could not have a public school allow release time in which religious topics might be taught. What you end up with then is what's called the Lemon Test from 1971, in which it's decided by the court that any aid from the government to religion must have a secular purpose. The end has to be general education, not religion. Its effect primarily must be secular as well. It must mostly simply add to education, not religious education. And there could be no excessive entanglements between the religious and non-religious establishment. In the case of Lemon, they decided the third prong was violated. Why? Because they said reimbursing religious schools for the teaching of secular subjects was not possible. It would require too much entanglement because those religious teachers could not help but proselytize. If you allowed them to teach math, they would be driven to proselytize and teach about religion. 2 + 2 = God, I suppose. But in any event, there would be this drive, and the only way to stop it from happening would be to have secular figures looking over their shoulders all the time. So it could be done, but it would require too much entanglement the secular with the religious. So we now have the Lemon Test. We have been living with the Lemon Test now for well over 40 years. What does it mean in practice? It is pretty much in the eye of the beholder. Clearly, what's happening here, and I'm in the process of concluding here, what's happening here is that you have, again, public education at the center of our concerns, a new view of the public school, which sees public school teachers not as independent figures or as representatives of a local community, but rather as arms of the government, in which you see local communities as themselves, again, primarily as arms of the government. So, some things continue to be protected, but in a very different way. Religious access to public schools, to public facilities, to public forums, tuition vouchers if the parents are choosing among a variety of schools. Religious schools can be among them. Purely symbolic representations, provided they aren't seen as providing an endorsement. And being excused from certain requirements only if it's not a general law. The famous peyote case, in which it was found that a general law against ingesting peyote, having been violated by workers who were members of the Native American Church, could not be inoculated against by the religious beliefs of these people. So then what do we have now? We don't have really a coherent view of religious freedom in the United States. Instead, what we have is an attempt by the Supreme Court to protect individuals, particularly individual expression, not a protection of groups, not a protection of religion itself, beyond certain tax breaks, and that, frankly, is dying out in a number of ways as well. You even have groups like Catholic Charities being told that unless they are pervasively religious in all aspects, they cannot gain relief from generalized laws such as those dealing with contraception and abortion, which obviously enough leads into the discussion of our panel, which I think will be useful to talk about. So let me just leave you with this. We have progressed, if you want to use that phrase, from a nation in which Americans saw themselves as members of communities and individuals to a country in which the federal government sees it as its job to protect individuals from impositions on the part of various communities. This takes place in the religious as well as other spheres, and it brings a very different dynamic to constitutional cases than we've ever had before. Thank you.
Steve, if you would. Thank you very much, Professor Fronin. I just want to remind you that at least we, the people of this great state of New York, considered the Declaration foundational, and we included it as the preamble to our Constitution in 1777. Not to mention, as you speak of free and independent states, you omitted that the reference to representatives of the United States, presumption of a union at the same time. All right. Today, we would be remiss if in speaking about, if you could do this, please, yeah. We would be remiss if in speaking about religious liberty if we did not mention two recent cases, two landmark cases, really, dealing with the topic, just decided by the court last term. I'm going to look at the case of Burwell versus Hobby Lobby. And what I want to do, briefly, I have 15 minutes here, is to discuss or try and analyze the court's ruling in this case so we can understand it. And then I'm certain this will raise a lot of questions for discussion. But let's look how the court wrestled with some of these principles Professor Fronin had just discussed. Okay? And we want to ask to what extent has the court applied or misapplied its principles in looking at this case. Okay, let's continue. Okay. We noted we provided an overview of the founders on religious liberty, and we mentioned the First Amendment, the two clauses, the free exercise and the non-establishment clause. Please continue. Okay. So how do I? Okay. All right. The issue in this case is whether the contraceptive mandate of the AHA, that is the Affordable Health Care Act, violates the religious liberty of a closely held corporation. Now, I want you to pay close attention to this term, closely held, because the court has given it a very specific meaning, is guaranteed by the Religious Freedom Reformation Act, 1993. In the court's oral arguments, they refer to the Religious Freedom Reformation Act as RFRA. So I will do so as well. Okay, RFRA. Sounds like something from Scooby-Doo. Of course, our legal system is adversarial, so it's important to know something about the plaintiffs and the defendants and the claims of each. The plaintiffs here, those who are initiating the lawsuit, were closely held companies, at least as regarded by the court, of Hobby Lobby and arts and crafts companies located out of Oklahoma, and the Conestoga Company, which was a cabinet-making wood company in Pennsylvania. They claim that the mandate violates their liberty of conscience in compelling them to provide support for abortifacients. And by this we mean birth control devices that destroy the embryo, and therefore they see this, according to their conscience, as the destruction of human life. So their objection is that the state is compelling them to do something repugnant to their conscience. The defendant is the Health and Human Services, as represented by Burwell, representing the Affordable Health Care Act. The government is claiming it has an interest, indeed, according to the dissent, a compelling interest in providing access to contraception. So these are the conflicting claims. It's important to recognize the context of this case. Interestingly enough, and I know many are surprised, this case did not involve adjudication of the free exercise clause of the First Amendment. It did involve an interpretation of free exercise, but the basis for that interpretation was not the free exercise clause of the First Amendment. And I'll explain why. The legal basis was RFRA, as I had mentioned, the Religious Freedom Restoration Act of 1993. And I need to take a moment to explain this. The context of this act was in response to Employment Division versus Smith, a case in 1990 which involved the question of whether or not peyote, a hallucinogenic drug, was protected under the free exercise clause for Native Americans, members of the Native American Church. The Supreme Court ruled no. In fact, Justice Scalia, writing for the majority, claimed that no exemption could be given to the Native American Church for the use of peyote in sacramental rituals. That, in fact, the state had a valid and legitimate interest, a general interest in preventing drugs and the spread of drugs. The standard here it's called the Smith test, and Professor Fronin mentioned it a moment ago, is that if a law passed by the government is validly neutral and of general applicability, it does not violate the free exercise clause. What this means is if we look at the scale of justice, it is tilted in favor of the government. Okay? The government, the court is going to, more often than not, side with the government if a law does not discriminate. For example, provided the law doesn't discriminate or target a specific religious group, it's going to be upheld and sustained by the courts. That's what we mean by a valid neutral law of general applicability. So the peyote case reversed the court's previous trend in granting exemptions. The court, in fact, the movement of the court from 1965 to 1973 in its precedents was to grant exemptions. In one case, for example, to allow the Amish in Wisconsin versus Yoder to withdraw their children from public schools after the age of 16. They were given an exemption for this on the basis of their religious beliefs, that their children would be corrupted by secular influences after this age. Okay. Now, in response to what Congress viewed as a very repressive standard in Smith, okay, the RFRA was passed. It was passed by a Democratic Congress by overwhelming margins and signed by President Clinton in 1993, the Religious Freedom Restoration Act. Let's look at this act very quickly, okay? I want to look at the particular language. It prohibits the government from substantially burdening a person's exercise of religion. Notice the term appears in this statute or this law, as well as the free exercise clause, unless the government, quote, demonstrates that the burden to the person is, one, in furtherance of a compelling governmental interest, and two, is in the least restrictive means of furthering that compelling interest. And in fact, the Congress sought to return to pre-Smith jurisprudence in granting exemptions to religious groups. The statute here, the RFRA, provides and affords greater protection to religious liberty than the First Amendment is interpreted through the lens of Smith. That's what's important here. The statute provides, if you will, greater protection to the religious dissenters. I want to look quickly at the four elements of the RFRA standard. One, the mention of free exercise for persons. This raises the question, as we'll see in Burwell versus Hobby Lobby, are corporations persons? Two, what is a substantial burden of religion? What does it mean to substantially burden the free exercise of religion? Three, what is a compelling government interest? By that we mean, what is the end or the purpose of the state? What is it seeking to attain? The court is concerned with the state's motives and whether or not those motives are discriminatory. For the least restrictive means test, let me give you an example. These are from actual cases here in the United States and in Europe. We'll look at the kosher and the halal analogy. One can say that the state has a compelling interest, for example, in providing for the humane treatment of animals, okay? And therefore, let's say, in view of this end, the humane treatment of animals, it passes laws that animals have to be stunned before they are killed, so they won't feel pain, all right? Now, of course, if you know anything about kosher and halal preparation of foods, that's the good stuff. We have quite a few places, good halal places right around here at RIT. I've been there. They cannot stun the animals before they slaughter them, right? So one can say, although the state may have a compelling interest in maintaining the humane treatment of animals, its means are too broad because they prohibit these religious groups, Muslim and Jews, from the ritual slaughter of animals. And therefore, one can still maintain the compelling interests, the humane treatment of animals, but one has to grant an exemption to kosher butchery, slicing of the jugular in this case. The RFRA provides a balancing test, okay? And we can think of jurisprudence very much as a balance, as an equipoise, or a weighing of different claims. On the one hand, there is the state's interest. And what is the state's compelling interest? On the other hand, there is the claim of the dissenter, of the minority in this case, Hobby Lobby, who are claiming that, again, their religious liberty is being violated by being compelled to provide birth control, of which they view terminates human life. Keep in mind that RFRA is a stringent test. The scale, in this case, is not even, but it is tilted in favor of the religious claim. The burden under RFRA is on the state. The burden is on government to demonstrate a compelling interest and to do so in the least restrictive means. If there are other means that can achieve this compelling interest that are less restrictive, okay, then in fact those have to be resorted to. I want to now look at Justice Alito's majority opinion in light of the framework that I just discussed. Persons. If we look at RFRA, we know that persons was an important element to the decision. Who would think that persons is controversial under law? Well, it is. It is controversial. And in this case, Justice Alito decided that for-profit corporations are persons, and he cited the dictionary definition of persons, which included corporations. Also, he noted that in this case, corporations are closely held. What does that mean? These are, according to Justice Alito, family-owned and run operations that are not publicly traded, and they have a closely held, closely shared religious mission or purpose. Okay? The substantial burden part of the test. Well, there's a substantial burden in two respects. One, the crisis of conscience violates a sincerely held belief in forcing these closely held corporations to provide birth control, of which they find objectionable. Two, if they are to fail to provide birth control, they would be fined, this is at least the claim, $475 million. The least restrictive manner. It's interesting, if we look at Hobby Lobby, this is the part of the test that the government failed. Why did it fail the least restrictive requirement? Because an exemption had already been given for nonprofit corporations. And in the mind of the court, in Alito's reasoning, it is, look, there's already, the government in making an exemption to nonprofit religious organizations is already conceding that there is a least restrictive means to going about this, to providing an exemption. And a tacit admittance to that corporations are persons. Finally, the compelling interest, and this is interesting, Justice Alito, in his majority opinion, does not really tackle this question. He simply says, we find it unnecessary to adjudicate the issue, because he says that this issue stands or falls in regard to the least restrictive test. So whether or not the government has a compelling interest in ensuring equal access to birth control for all women, for Alito, need not be considered because the government has already failed to provide the least restrictive means, even if we admit that this is a compelling interest. Quotes from Alito's majority opinion. The purpose of extending rights to corporations is to protect the rights of people associated with the corporation, including shareholders, officers, and employees. Protecting the free exercise of rights of closely held corporations thus protects the religious liberty of the humans who own and control them. Again, extending free exercise of religion to closely held for-profit corporations. Any suggestion that for-profit corporations are incapable of exercising religion because their purpose is simply to make money flies in the face of modern corporate law. That's what he's arguing. In any event, our decision in these cases is concerned solely with the contraceptive mandate. Our decision should not be understood to hold that an insurance coverage mandate must necessarily fall if it conflicts with an employee's religious beliefs. Other coverage requirements, such as immunizations, may be supported by different interests and may involve different arguments about the least restrictive means of providing them. What Justice Alito is saying here is that this decision is narrowly tailored to apply to closely held corporations involving the contraceptive mandate. It's not, it will not, he's hoping, expand to exempt people from immunizations, of which some religious groups may object to immunizations, and a dissent points that out. Our responsibility is to enforce RFRA as written, and under the standard RFRA prescribes, the contraceptive mandate is unlawful. Let's look at, almost done here, Ginsburg's dissent now, provide a balanced treatment of this. Justice Ginsburg argues that the interpretation of RFRA is too broad. Congress never intended the free exercise of religion to apply to for-profit corporations, she argues. She also distinguishes, she said, granted, exemptions have been made to nonprofit corporations, but these nonprofit corporations are religious groups. And you just can distinguish religious groups from for-profit corporations. Third, she claims that Alito's opinion in no way considers the effect that this has on third parties. It mostly considers just the claim of the plaintiff's conscience, and that there is profound harm done to the third parties, in this case women, in denying their access or frustrating their access to contraception, which will enable them to participate equally in the political process and in society. Also, remember, RFRA demands some substantial burden. Justice Ginsburg claims that, look, what is the substantial burden on the part of Hobby Lobby? The fact that they have to contribute towards, or their insurance has to pay partially for birth control? This is too indirect, too attenuated. We would say perhaps it's more direct if they were forced to use the methods themselves. But this is for their employees. You cannot refer to this as a substantial burden, therefore. And of course, she discusses a parade of horribles, that in fact the exemption in this case would open floodgates to other exemptions. Immunizations, people will claim exemption for immunizations on religious grounds, and other tests. Let's look at some quotes from Ginsburg's dissent. She says, in a decision of startling breadth, the court holds that commercial enterprises, including corporations, along with partnerships and sole proprietorships, can opt out of any law, saving only taxes, they judge incompatible with their sincerely held religious beliefs. The free exercise of religion is characteristic of natural persons, not artificial entities like corporations, she argues. No tradition and no prior decision under RFRA allows a religion-based exemption when the accommodation would be harmful to others, the third party argument. In conclusion, has the court struck the proper balance? Who do you agree with? Who do you think has the best of the argument here? You can see the conflicting claims. Has the court applied or misapplied some of the principles Professor Fronin spoke about? What next? There is an opinion right now working through the 10th, or a case working through the 10th Circuit Court in which a group is claiming doesn't want to have any coverage of birth control, wants it completely exempted. Thank you so much. At this time, I want to introduce my wonderful colleague, Lauren Hall, an assistant professor of political science here at RIT. She received her PhD from Northern Illinois University in 2007. She's written extensively on the classical liberal tradition, including articles on Burke and Montesquieu. She also works on the track in political science and the life sciences here at RIT, writing and teaching on topics such as the ethical political implications of biotechnology. Her recent book, Family and the Politics of Moderation, was just published by Baylor University Press this year, and she is bringing a world-class group of scholars to RIT in May 2015 for a symposium on spontaneous order in the social and political sciences. She's going to talk about the case in our backyard, Greece versus Galloway. Please welcome our final speaker, Professor Hall.
Well, thank you, Professor Fornieri, for inviting me and for leaving me with a nice, fresh audience ready to hang on every word. So I'm going to make this relatively quick because I do want to make sure that we can get to some questions and discussion. So the case that we're looking at right now is Grease versus Galloway. It deals with the separation of church and state, particularly at the local level. So this was a 2014 case, again, right in our backyard. Very quickly, the two plaintiffs were Susan Galloway and Linda Stevens. Galloway is Jewish, Linda Stevens is atheist. Both of them are Grease town residents. And their argument was that after a long period of time of going to Grease town meetings, they noticed that all of these town meetings started with Christian prayers. And so their concern was that that this violated the Establishment Clause. And we'll look at the specifics of that case. A little bit of background. Prior to 1999, meetings opened with a moment of silence. When a new Grease town supervisor was elected, he brought with him a tradition from the county legislature where he had served of opening town meetings with a prayer. Between 1999 and 2007, every meeting opened with a Christian invocation. When the plaintiffs began complaining, we started to see a shift. So they allowed a Wiccan and a Baha'i person and a Jewish layman to come in and give those invocations. As background, of course, though, Greece is something like 95% Christian. There's about a 3% Jewish population and another very small other population of religious minorities. So the big issue here, and I've tried to sort of color code some of the major issues, is whether the Court of Appeals erred in holding that a legislative prayer practice violates the Establishment Clause first, notwithstanding the absence of discrimination in the selection of prayer givers or forbidding exploitation of the prayer opportunity. So the two major things that previous courts have looked at in the Establishment Clause is whether there was discrimination, i.e. is the town discriminating against a particular religion, and are you using the prayer opportunity as an exploitative act, or i.e. are you using this to proselytize? And so the question here is prayer alone enough of an establishment, or do you need discrimination and proselytization at the same time? So Galloway's argument was twofold. The first was that the procedure for choosing speakers unfairly preferred Christian speakers over non-Christians. And then the second concern was that the prayers themselves were unconstitutionally sectarian. So to tackle the first thing, the way that Greece chose these speakers was they had a list of religious establishments in the town of Greece that was put together by the Chamber of Commerce. And they would move through that list every month and choose speakers from that list. Eventually, they had a list of people who were willing to do this, and so they would just choose people off of that list. It does happen that the majority of religious establishments in the town of Greece were Christian. There was one Buddhist temple that was inadvertently left off of that list, but all of the synagogues in the area are actually right outside the Greece town line, and so they didn't show up on the list that the Chamber of Commerce put together. Again, there's no evidence that there was intent to discriminate. It simply happened that the list that was put together was not a complete list of religious establishments in the area. The second concern was that the prayers themselves were unconstitutionally sectarian. A lot of the prayers mentioned specifically Jesus Christ as a savior. So the idea is that we're not talking about a sort of neutral or generalized idea of God. We're talking about a very specific kind of Christian sectarian understanding. So the major precedent in this case is Marsh versus Chambers in 1983. This case dealt with the Nebraska state legislature and their practice of opening legislative sessions with a prayer. And the holding in that case was that to invoke divine guidance on a public body entrusted with making the laws is not, in these circumstances, a violation of the Establishment Clause. It is simply a tolerable acknowledgement of the beliefs widely held among the people of this country. And Marsh used as the primary historical example, the example that Professor Frohnen brought up, which was that legislative prayer was very common at the founding. And in fact, this came up in the Marsh case and then comes up again in Justice Kennedy's decision. Within days of passing the Establishment Clause or okaying the language of the First Amendment, Congress also appointed chaplains for both the Senate and the House of Representatives. So the argument in Marsh is that you can't have a historical practice that was passed at the exact same time as the First Amendment cannot be unconstitutional. Okay. So this is the concern that, that primarily comes up. So Marsh versus Chambers is the really important precedent, but there are a couple other relevant cases. Lee versus Wiseman in 1992 looked at school prayer and found that invocations are not permitted. The major controlling issue in this particular case is that schools are a different kind of environment, that there's a kind of coercive element to public prayer in schools, and especially at public events like a graduation, where you either have to miss the graduation in order to not be a part of the prayer, and so that was too coercive, the court believed. The second case, which again Professor Fronin brought up, was the Lemon case, and that's the Lemon versus Kurtzman in 1971. The part of the Lemon test that is most relevant for this particular case is emphasizing limiting government entanglement with religion. And this comes up again in Kennedy's decision. So what makes these cases different is that both of them have to do with school children, and both of them have to deal with the way in which local governments were entangling themselves to some degree with religious organizations. So there's two major limits established by precedent, and this is what the court was trying to look at. Governments cannot use the prayers to proselytize, so that's the one key concern. And they cannot discriminate against or advance a particular faith. So what the court was looking at in this particular case was, does opening a town board meeting either proselytize or discriminate against people of different faiths? Obviously, Galloway believed that it did, and we'll see what the court's opinion was. A couple notable discussions came up during arguments, and these are going to come up in the opinions as well. The first has to do with whether religious customs that are rooted in history are less problematic than new innovations. And so the question is, how do you respect the religious traditions and heritage of a people while at the same time protecting individual rights within the context of local government? Another important concern was whether religious invocations single out citizens of other religions. So the argument that Galloway made was that if you didn't want to participate in this public prayer, you actually had to remove yourself from the room, which was going to single you out as a citizen who does not believe the same things as other citizens. So the concern is that this puts too much pressure on citizens to protect their own religious beliefs. Another concern that comes up is whether there are any prayers that are going to be acceptable to people of every possible religious belief. So Galloway made the argument that we needed more neutral prayers that talked about a sort of generalized God, as opposed to sectarian prayers that talked specifically about Jesus Christ. And one of the concerns that comes up again in the opinion is whether it's possible to have a truly neutral prayer of any kind, or a prayer that every possible religious organization would agree with. And then the final concern, and this is crucial for Kagan's dissent, is whether prayer at legislative meetings may be different from prayer at town meetings, whether there's something qualitatively different about town meetings where citizens come to actively petition the government, as opposed to something like the Nebraska State Legislature, where you have religious people speaking simply to legislators, and citizens are not present or not involved in the prayer in that way. So the decision, which was written by Justice Kennedy, was that the town of Greece does not violate the First Amendment by opening its meetings with prayer, that comports with our tradition and does not coerce participation by non-adherents. So he follows very heavily from the Marsh precedents here. Now, the important thing to keep in mind about this is that there wasn't a solid majority opinion. You have Kennedy's opinion. He's joined for parts of it by other conservative justices, but other conservative justices also wrote concurring opinions. So it's not a very super strong opinion in that sense. He does provide guidance for future cases. So he says, absent a pattern of prayers, and this is the crucial part, that over time denigrate, proselytize, or betray an impermissible government purpose, a challenge based solely on the content of a particular prayer will not likely establish a constitutional violation. So Kennedy's argument is that there's no proof of discrimination, there's no evidence that Greece purposely sought out only Christian thinkers, and in fact, when complaints were lodged, they welcomed other religious denominations to come in and give those invocations. So there's no evidence of discrimination on the one hand, and then there's no evidence that there was proselytizing or any kind of undue coercion. So his argument is that ultimately this is the same kind of situation that we find in Marsh. A couple interesting concurring opinions. Justice Thomas made the case that the case should be dismissed because the Establishment Clause does not apply to the states, and that the Establishment Clause was improperly incorporated by the cases that Professor Frohnen brought up. Thomas is always good for a losing battle, right? He always sort of throws in that. It's a very radical argument. So his argument is the states were always allowed to establish religions. That was very clear at the founding, and so this shouldn't even be an issue at all. Scalia doesn't go that far, but he joins Thomas in the second part of the decision, and he says, look, even Marsh goes too far. We shouldn't be concerned about subtle pressure here. What we should be concerned about is actual legal coercion. Were people forced to pay taxes to pay churches? Were people forced to give oaths in front of public meetings? Unless there's legal coercion involved, subtle pressure, subtle coercion of various kinds is not relevant, right? So the standard in Marsh is actually too broad, according to Thomas and Scalia. And then finally, Alito and Scalia respond to a couple important things in Kagan's dissent, the first being that intent matters, which we'll look at in a second, and then they're concerned that Kagan's dissent is overly broad. So we're going to switch gears and look at the dissents really quickly, and then hopefully get some good discussion going. Breyer's dissent is fairly straightforward. His major concern is that the town's procedures were not broad enough. So the town should have sought out people of other religions and explicitly directed folks to be non-sectarian. The non-sectarian direction, by the way, is one of the major concerns of both Alito and Kennedy, in that by having local government officials direct the invocation speakers, that would actually create an entanglement with religion, because you would be essentially censoring the free speech rights of the religious speakers. So there's a conflict there, as I think Professor Fornieri pointed out as well. Kagan's dissent, I think, it's extremely passionate, and it makes a couple really important arguments. The first, and this is the most important, is that town government is different from legislative or state legislatures. It's what she calls a hybrid. And it's a hybrid because in a town board meeting, you're not only going to watch legislators make law, but you're also going to actively petition the government. You're asking government officials for things, whether those things are permits or variances or to get out of tickets or to complain about the state of the world. I'm sure you guys have been to local government meetings. So it's a hybrid, which means that citizens are directly petitioning their government. And so it's not the same thing as simply passively watching a legislative session. You're actively involved, and therefore citizens get sucked into public prayer in these contexts in a way that they don't in normal state legislative sessions. So her argument is that Marsh is fine. Legislative sessions alone can have public prayer. What changes in this position is that you have petitioners directly petitioning the government, and citizens are directly involved. So the prayers are directed at local residents, and the prayers are highly sectarian. But she argues, again, that Marsh itself would still hold. She has no concerns with Marsh itself because the tradition of legislative prayer is a very old one. It goes all the way back to the founding. So her concern, again, is this sort of hybrid governmental system. So here's a quick quote from Kagan's dissent. Here, when a citizen stands before her government, and she's referring to the history in the United States, whether to perform a service or request a benefit, her religious beliefs do not enter into the picture. So we need to be absolutely neutral toward citizens when they come before us in their capacity as citizens. So the results very quickly, Greece asked an atheist, or an atheist asked Greece, and Greece said yes, to give the invocation, which he did shortly after. And then shortly after, they changed their bylaws to require all invocations to be affiliated with a religious assembly in the town of Greece or outside of Greece that people attend. The reason for this, or the rationale was that they were flooded with requests to give the invocation by religious people of all varieties. And so they felt the need to limit it to at least religious assemblies that people in Greece would go to. The kicker, of course, is that this seems to rule out atheists or humanist speakers and seems to restrict the invocations to solely religious believers. So that's a concern of many people. Some important questions we can just think about and maybe hopefully discuss on the panel. One of them is how far religious content has to go before it establishes a religion. So is simply giving a prayer at a public meeting any kind of establishment? Does there have to be this pattern that Kennedy talks about? So how exactly are we interpreting that? If the majority of community members are Christian, as is the case in Greece, is public prayer an establishment of religion or merely a recognition that there are shared moral and religious values at play? So this is a really important kind of concern, especially for local governments, which again, as Professor Fronin pointed out, are supposed to be sort of organic and they're supposed to reflect the values of the people who live there. If 97% of the people who live there are Christian, do you have to have 97% of the prayers be Christian, or do you have to alternate sort of every week you have a Muslim and a Buddhist? You know, how is that going to work? And then finally, the question is, what role should religion play in public life, if any? We are not a secular state in the way that France and Turkey are, and so one of the things that we have always, and this goes back to Professor Fornieri's argument, that there's a kind of tension between the Establishment Clause and the Free Exercise Clause. So we have always allowed people to bring religious symbolism and their faith in general into the public sphere. The question is how to balance that with the very delicate nature of local government activities. So I'll leave it there, and hopefully we can have some good talks.
Well, I thank you for being with us. Do you have any? I'm sure we have some questions. Please. Bruce, can you join us? Is this the speaker's here? This is nice. I need one of these. Can I borrow this?
Yeah.
Thank you, everyone, for coming. It's been long. But worth it.
To go back to the case about whether contraception is a burden upon the religion of the employers.
Yes.
And you said that the judges had the Supreme Court decided that the federal government had already broken the third rule of the lemon.
The RFRA.
RFRA,
yeah.
They had already implemented
The least restrictive means.
The least
Yes.
restrictive mean
Very
had already been implemented as an exemption for nonprofit organizations.
Yes.
But I thought that the third rule was you have the least restrictive means that still accomplished the aims of the federal government, and the aims of the federal government was to support the providing of health care for citizens regardless of their religion. So wouldn't
They're still providing health care.
if there's an exemption for for-profit organizations, would that mean that they're not providing health care?
They're still. So I'm not following it completely.
No, I think the question is, would it not in fact undermine the purpose of the legislation if they were to extend the exemption to for-profit corporations? And I think the answer is this, the argument is that this is only nonprofit corporations, there's only a few of them, and there's even fewer closely held corporations that are going to take advantage of this. So the number involved of organizations that would stop providing coverage specifically for abortifacients would be so small that it would not in fact harm the generalized purpose of the legislation, which is to make these forms of birth control generally available.
Okay, that answers the question. Thank you.
Thanks. Sorry about that. Bruce, during the oral argument, the lawyers on the side of Burrell said that Walmart would constitute a closely held corporation by this definition. Do you agree with that?
Of course not.
Why? Right? If you look at the board members, they're all from the same family. There's a religious mission.
Okay, is it closely held?
That's the argument can be made that it's close to.
Publicly traded.
I thought it was publicly traded.
It is publicly traded,
But it's not a closely held corporation. This is an extremely narrow decision, extremely narrow. It only applies to closely held for-profit corporations, and it only protects what in a sense in essence, really are free expression rights. You've shown that you have this specific value, and you are unanimous enough, and you've got it, this value clearly enough stated that it can be said to be essential to you.
By the way, I think it's worth mentioning that Kennedy, in his concurring opinion here, Kennedy sides with the majority, emphasizes the expressive element of this.
That's what,
So that's why he goes along, and that's, any other, I'm sure we have more questions. Ed?
Follow up on that question. It seems to me, I think it was mentioned briefly, that we are only looking at the owners of these corporations. What about the employees? Can't you say that in fact, those who are imposing their religious values on the employers, an employer who's an atheist or for whatever reason doesn't think there's a problem with contraception, and therefore, even if it's $5, you're compelling her to make another arrangement because of your religious beliefs that you're exercising through a corporation. I mean, did that come up? Is that something that you might want?
That did, the government made that claim.
What's your
Yeah.
position of that? That you're siding with somebody who is not even being required himself to use the contraceptive, but he's imposing his own views on this employer.
Yeah. You know, I certainly think that that's a, you know, that's a concern, and under our system, right? I mean, the healthcare is for the most part covered by businesses, right? Employers. So the court, I think, tries to answer this by narrowing it. Again, that it's only going to apply to closely held corporations in this case, and I think they tilt the balance. They tilt the balance in favor of the religious dissenter with the thought that there's still access to birth control. Right? They're not being denied birth control. Right? Go ahead.
No, I'm not comfortable with the way that you're phrasing that, and
Me or him?
maybe we have a difference
Oh,
and maybe not.
yeah.
I'd sort of be interested in that. It seems to me that the basis of this has to be that there's something unusual going on in that this is a mandate. The government is telling employers what they have to provide for their employees. Traditionally in the United States, employers sometimes do and sometimes do not. And even under Obamacare, many employers do not provide any health care. It is not a right that you have yet. Okay, so under that, employers often provide a different set of benefits under the health care plan. What we have here is the question of whether it is okay for the federal government to specifically require a closely held corporation to provide a benefit that violates their conscience. So does that mean then that the other choice is to violate the conscience of the employees? No, what's being denied to them is a monetary benefit. And those are, apples and oranges. They're very different things.
You don't see it as an imposition on the part of the corporation to its employees?
No. Money. In fact, if you look at the way that the argument is made, it's, will this make that benefit, the abortifacients, less available? The argument isn't, am I being denied it? It's, is it as a policy then less available, presumably because more expensive? It's done in monetary terms. That's the argument on both sides, essentially.
What if we take the analogy in terms of immunizations, and you have a religious group that claims they're not going to pay for immunization for their employees? Would that be?
No, the argument, and I think Alito was correct here, is that this would not extend to immunizations, not because failure to provide that is an imposition on the employee, but because the governmental goal there, which is to prevent outbreaks of the plague, would simply not be served by these kinds of exemptions. It would be so undermined because you'd have people catching these various diseases that it would not be reasonable to expect that you would allow even closely held corporations where this violates their beliefs to opt out of it. They're just not using this calculus in general terms. It got mentioned by one of the judges.
So, someone else, please. Steve, yeah.
Could you not expand the argument with preventing
either of you want to address?
Well, I
that?
think
Because
I think the difference would be that the purpose of the the purpose of the ACA is not to prevent unwanted pregnancies. So there's a distinction, I think, insofar as the purposes of the laws are different in that particular way. That's how I would interpret it.
Quick follow-up, yep.
The purpose of the ACA is to support the general welfare of society in terms of its health care. That's an aspect of it, in the same way that if I fall at work and hurt myself and I can become healed and better, I can then contribute back into the economy. It's just different flavors of.
No court is going to allow you to read any legislation that broadly. This is not, because that is making it whatever we want to make of it. It's not a valid legal argument.
How the Supreme Court works.
Andy, you had a question?
Yeah, it was kind of in his vein, but I think Bruce mentioned it earlier, maybe answered already, but what is to stop future companies being closely held and popping up around the United States by various religious groups? Muslims, talking about Sharia law, or Scientologists not wanting to cover psychological care, Jehovah's Witnesses not wanting to pay for blood transfusions, so on. Is there a slippery slope argument in that regard?
Again, this is extremely narrow. There aren't very many closely held corporations, and it would depend on what it is that they're refusing to support or attempting to support. It was Sharia. I'm not sure where that goes, except I think it shows how far you have to stretch in order to make this kind of slippery slope argument, because it's not like an employer has the right to cut off the hands of any of its employees.
But
I
this
don't
is,
know
yeah,
what
this
specific-
is Ginsburg's slippery slope argument in her
It
dissent.
doesn't
That's her
really,
concern, yeah.
it doesn't really work, though.
What about blood transfusion, Jehovah's Witnesses?
Specifically, that's one that Alito specifically addressed.
But you can test it later in court if you want to bring it up. You can always sue your way to the Supreme Court.
I'm sorry?
You can always sue yourself to the Supreme Court and argue that it was narrowed in this respect to contraception, but what about other aspects that we can now narrowly address?
The problem with that argument is that you can't come up with believable examples, because all of the examples that might qualify there are ones that have a broad health impact, and therefore there's a compelling state interest. The other examples that you might think about are going to be much more limited in their impact.
We had a question from up here, please.
I had a question about the Greece.
Please.
I had a question about the percentages, like the 97% was Christian. How did they define Christian in that sense? Was it just like people who go to church, or people who just say, "Hey, I'm a Christian"?
Actually, Alito addresses that in his concurrence, and he says it's very hard to get adequate data because the town of Greece doesn't collect. I mean, almost no town collects data on the religious makeup of its population. But from the little data that we have, it's something like, I mean, it's certainly in terms of the number of the proportion of religious assemblies that are Christian. It's 97% or something. Religious assemblies in Greece are Christian, and then. You know, I'm not sure exactly where the data comes from, whether it's the census data or what, but, you know, I think it's people who subscribe generally to the Christian faith, who believe in some kind of Christian God. So it's not people who are going to church every Sunday or anything like that.
We had a, yeah, please.
I was wondering if, in the Hobby Lobby case, if it sets a possible precedent for how third parties are treated, because I know that, unless I'm remembering correctly, that in the Amish case, I don't remember what the case was called, but that the third party being the children was not really considered in the ruling. They were ignored as far as I can
No,
remember.
that's not true. You're talking about Wisconsin against Yoder, right?
Yoder.
Yeah.
Not in the majority, that Justice, the author of Griswold, Douglas, claimed that the decisions, the views of the children should be taken into consideration, and he had mentioned that in the case. So it wasn't
No, it's more complicated than that. He was saying that you needed to treat children as if they are adults and talk about them being exposed to a wide variety of viewpoints, that the old order Amish are in fact too insular, and therefore the children are being brought up in a stunted atmosphere.
Well, Douglas was saying, no, it's a question of individual autonomy for the
Right,
kids.
among youths,
For the
among
youth,
those
yeah.
who are highly young. The majority decision did in fact address the effects on the children in the sense that it said, will these children be given the skills necessary to be productive members of society? Now, it was looked at from the viewpoint of society, sure.
Right,
But it clearly was intended to talk about the role of parents and the duty to create employable adults.
It did talk about the effects on the kids, but I think it was a question of the self-determination of the kids in making the decisions
You're dealing with
themselves.
minors there, so that's
Yeah.
always dealt with differently.
Question here. Is it true, my understanding, that the details regarding in the Affordable Care Act that dealt with, for example, the requirement for the abortifacient drugs was really not in the act itself, but it was the detail that was then provided by Health and Human Services and the bureaucrats in that organization? And if that's true, is it possible with the next administration or some further administration that those details could be changed and we could be back again with a whole set of other scenarios and details that are totally different than what we have now, which begs the other question is, the hell is the government doing involved in this in the first place? At least that's my opinion.
Who is that guy?
Is that true? So that it really was, those were put in later and the general act itself did not have that level of detail.
Welcome to administrative law.
Yeah, it was put in subsequently.
is in
But
many
what
ways
subsequently?
arbitrary.
It was included later, yes.
Yeah, which means
But there was also,
it could be changed then, right?
it was highly recommended just to protect the health of women and to allow their equal access and competition in society. Yes?
Question about the Greece case. It was talking about the sectarian nature of the prayers and how it would be a better option to have a prayer that appealed to a more general idea of God. How then do you reconcile the problem of people who have no belief in God? How can you have a sectarian prayer that appeals to an idea of atheism or agnosticism?
The short answer, of course, is that they were not primarily concerned with atheists. The reason for these invocations is to sort of remind people of a higher power, to unify people around, sort of religious beliefs. And the understanding, of course, is that there's going to be, a sort of minority of atheists, and that this is not necessarily, even the respondents, even the plaintiffs, one of whom was an atheist, said, look, just talk about a general God and it'll be okay. They weren't talking about secular, because then you're talking just a moment of silence or something like that. So even the atheist said, look, just talk about a generalized God and we'll be okay. So the concern was that there was a lot of references to Jesus Christ specifically. But you're right, and this is what has come up in recent days with the new way that Greece has now chosen the invocation speakers, is that seems to rule out atheists and humanists altogether. Did you want to follow?
Yeah, I want to say something real quick. Part of the court's establishment jurisprudence has been this striving for neutrality, that the government cannot prefer religion over non-religion. However, whether you think that's misguided or not, but was that principle violated here? Were they, is this government neutrality, or can one see this as an endorsement of religion, an accommodation of religion?
First of all, that's not a generalized rule. It's something which is a fairly recent origin and applies in the public school context, but has never been applied in the realm of what's considered to be, ceremonial deism.
In Marsh versus Chambers and in those.
Well, there are a whole series of cases, actually.
But
yeah.
in the school setting, certainly.
Yeah. So the neutrality position, which has never had a sustained dominant majority for it, it wins now and again. Okay, doesn't apply in this kind of case at all.
Yeah.
Never has been seen as.
you've had your hand up a long time. Go ahead, please. And then I'm just going to take maybe one more question, and we'll have to conclude. I appreciate everybody being troopers here.
So, going back to the Holly Valley case, sorry, I understand that the exemption is so narrow that it would not undermine at all the federal interest, the federal government's interest to provide health care for women. And I also take in point that maybe the federal government should be involved in healthcare at this level in any way. But and this might be comparing apples to oranges. But how would you? Because you mentioned that the federal government should not be able to mandate certain corporations to do this kind of thing. So then, how do you view things in the light of affirmative action, where the federal government mandates a certain amount of minority employees?
Bruce is pretty consistent on these issues.
Fair enough.
A certain amount of percentages, they're not supposed to mandate percentages, they're supposed to mandate procedures and attempts. Of course, that ends up being percentages because the mandate isn't really achievable, other than with solid
No numbers.
percentages required. Yeah.
No quantitative determinations. One more question from a student, please. Sorry, Ed. Yeah, boy, I don't want to cut. Maybe we'll go for 3 more questions. All right, quick, because I don't want to cut you guys off. Please, what was your name?
Brian.
Brian, please. And then this is what we're going to do quickly. You there on the left, and then right up there, because we had 3, and then we'll cut it off.
First of all, I think it was during your presentation you mentioned Judge Thomas's perspective that the Establishment Clause doesn't apply to states. I was wondering how much that would hold up, and if, in the case of Greece, if we assume that saying Christian prayer was paramount to establishing Christian religion, is that admissible as long as you're not persecuting the beliefs of another, or is the mere act of saying the prayer considered persecuting the beliefs of other, as the Jewish Greece seems? Yes.
I think the argument, and Bruce might be able to weigh in here. Again, I mean, I think the argument that Thomas would make, Thomas is bringing up the rear in a lot of ways, but his argument would be that local governments are really, they have a lot of freedom to establish various kinds of religions, and so they can, they could do totally sectarian prayer of, a very, very specific sort without any kind of constitutional problem at all, because really the Establishment Clause only applies to the federal government. So this would open, if Thomas won, which he never will, it would open the floodgates for local and state governments to make religious dictates of various sorts.
You'd have to overturn Everson.
In addition to the fact that this is just tossing a bomb to see what happens, I think that's right. But you might want to keep in mind what would actually happen in a lawsuit here, which is not that it would stop, that everybody would say, oh, it's local, you can't do anything about it. It's just that the lawsuit would go to the New York Supreme Court. And chances are in New York, you'd have a problem, because New York is almost certainly going to be the kind of a state that would have a problem with these sorts of activities. You'd simply have 50 different sets of rules regarding what is permissible and what isn't.
Haven't you been hard enough on New York State? I'm going to take it to the Adirondack Mountains now and say,
I'm going to take it as a compliment.
please, yeah.
Would closely held corporations that need to mandate that they not use abortifacients from the get-go, or would they be allowed to change their policies if they decided, if the people at top decided to change them for whatever personal reasons they came up with? What would the ruling say on that?
Go.
It'd be hard, because you'd have to show that it was a sincere belief.
That's right.
And there would be, if it's new, there would be a real view that maybe this is done for political or even economic reasons. They're allowed to, in a sense, interrogate you about that. So I'm not saying that if it's new, it wouldn't happen, but it makes it much more difficult.
And one more, thank you. Yep.
Yes, there's a situation, I think it was in Oklahoma a while ago, where there was a town hall where they posted the 10 Commandments, and another group raised money to erect a statue of Satan right next to it, on the grounds of if they include one religious symbol, they have to include any religious symbol.
Right. Yeah. Yeah, I like to call that the Santa Monica answer because Santa Monica, for a number of years now, has had an area for everybody and anybody to post something around Christmas time. And they just do it by lottery. So if you want to take your kids to enjoy the Christmas season, you can go to the Santa Monica area for this, and they can see a crash, they can see a nativity scene, they can see a Buddhist scene, they can see the devil, they can see secular humanists. So the kids can really enjoy the full holiday spirit as it was intended to be seen.
Inclusive.
Well, I like to call them the interior decorating cases, where the court decides, all right, we've got a cross here. Is that going to be okay? Well, it depends on how close the cross is to a menorah, or even better, Santa and the reindeer. Okay, because it has to be sort of sterilized, made okay by these
Secular
other
symbol.
symbols. So, in point of fact, those Satanists are, sanitizing those 10 commandments. So there's certainly not going to be anything in the Supreme Court that's going to say no to that. The only question is whether there's anything the locality can do about that. And the answer is it's extremely difficult under current doctrine, because what current doctrine is about is protecting the rights of individuals to express themselves, including in this area of religion. All right? Religious exercise and establishment cases are not what they used to be because they've sort of been sucked into the idea of another individual expressive right, like the other ones. And most Americans, I think, are perfectly happy with this. And this is something conservatives as well as liberals on the court use in making these decisions. It ignores the rights of groups, but that's how it is. So it's just a matter of, can you express yourself? And if it's a public forum, nothing to be done about it.
Thank you so much. I'd like to meet with my colleagues down here. Those who have attended, please come by. And thank you, everyone. You folks have been troopers. We've really enjoyed it. Thank you, Bob Paquette. And we'll see you. Amen.
International Studies. He was the Charles Evans Hughes Professor of Jurisprudence at Colgate University last year. He was a legislative aide to United States Senator Spencer Abraham from Michigan and is senior fellow at the Liberty Fund. Bruce is a prolific author. He has edited or authored 14 books. 2 of his volumes, The American Nation, Primary Sources, and Rethinking Rights, were named outstanding academic titles by Choice. His articles have appeared in journals including the George Washington Law Review, the Harvard Journal of Law and Public Policy, and the American Journal of Jurisprudence. His research interests focus on religion in American public life, the nature, development, and prospects for constitutionalism and human rights. He holds a JD from Emory University School of Law and a PhD in government from Cornell University. He is currently teaching at Ohio Northern University Law School. His most recent book, Constitutional Morality, Structure, Norms, and the Rule of Law, will be released next year by Harvard University Press. Please welcome Bruce Fronin.
Thanks so much, Joe. Thank you for that kind introduction and for all the work that I know you, RIT, and the Center for the Study of Statesmanship have done. Thank you for bringing me here. Thanks also to Bob Paquette and the Alexander Hamilton Institute. I greatly appreciate and am honored by presenting the lecture co-sponsored by the Institute. Thank you all for being here. We need to talk today a little bit about religious freedom in the Constitution. And I hope that we'll remember that what we are talking about, in part at least, is religion, which is to say, a social practice, not just free exercise by individuals, not just the lack of establishment by the government. But the practice by groups of like-minded persons of worship and ways of life. It's this understanding that I think is necessary in order to understand what lies behind more recent Supreme Court decisions and actions in our broader culture, which seem much more, since the era after World War II, seem much more to be concerned with the relationship between the federal government and each of us as individuals, either limiting us in our activities so that they don't harm others, or protecting us as individuals from potential tyranny from localities, states, and various social groupings, including religion. It is an interesting turn to a long tradition in which our pluralistic society has been seen as being made up by not just individuals, but the fundamental constitutive groups that individuals form.
I want to welcome you to the 7th Annual David Aldrich Nelson Lecture in Constitutional Jurisprudence. It's held every year on Constitution Day, September 17th. The lecture honors Judge David Aldrich Nelson, who was a charter member of the Alexander Hamilton Institute's Board of Directors and who served for more than 2 decades on the United States Court of Appeals for the Sixth Circuit. Our event tonight is sponsored by the Alexander Hamilton Institute and co-sponsored by our very own Center for Statesmanship, Law, and Liberty here at RIT, along with the Political Science Department. I would like to thank Bob Paquette, the director of the Alexander Hamilton Institute, for his generous support, my dean, Jamie Weinbrink, my chairman, Sean Sutton, for his continued support. We will continue our Constitution Day events with a lecture tomorrow on virtue, statesmanship, and the Constitution from the same speaker, Bruce Fronin, whom I will introduce in a moment. Tomorrow's lecture will be at 4 o'clock in the Skelny Room of the Schmidt Interfaith Center. But tonight, our theme is religious liberty. After traveling to America in 1831, Alexis de Tocqueville, French foreign observer, observed in his great work, Democracy in America, a work aptly described as once the best book on America and democracy, that it was, quote, the religious aspect of the country that first struck his eye, unquote. He noted that the greatest part of English America, he referred to America as Anglo-America or English America, Tocqueville noted, has been peopled by men who, after having escaped the authority of the Pope, did not submit to any religious supremacy. They therefore brought to the New World a Christianity that I cannot depict better than to call it democratic and republican, unquote. The religious foundations of America's origins are well known. The Puritans in Massachusetts Bay, continuing the Protestant Reformation in the New World, strove to build a city upon a hill, an enduring symbol of our self-understanding. The Pilgrims in Plymouth Rock, a more radical Puritan sect, established the Mayflower Compact, the first written constitution in the New World based on consent. Pennsylvania was a self-described holy experiment started by the Quakers. Rhode Island, once referred to as the sewer of New England, was an experiment in the separation of church and state. The phrase later used by Jefferson, separation of church and state, was coined by Roger Williams, the founder of the colony of Rhode Island. Maryland was a Catholic haven, which passed a Toleration Act as early as 1649 that included the phrase, the free exercise of religion. We may all be familiar with Benjamin Franklin's proposal for a civil religion that would strengthen the country's political institutions in his autobiography. America became a refuge and a haven for those seeking to practice their religious liberty. Religious diversity, at least amongst Christian sects, was a fact, a notable feature of the colonies, and quite an achievement given the wars of religion that had devastated Europe a century before.
The New World continues that those who signed the document, quoting, having undertaken for the glory of God and advancement of the Christian faith and honor of our king and country, are now forming a new colony, and we do, quoting, solemnly and mutually, in the presence of God and of one another, covenant and combine ourselves together into a civil body politic for our better ordering and preservation and furtherance of these ends. And by virtue thereof do enact, constitute, and frame such just and equal laws, ordinances, acts, constitutions, and offices from time to time as shall be thought most meet and convenient for the general good of the colony, unto which we promise all due submission and obedience. So what we have here, then, again, what can well be said to be the first constitution of the English settlers. There had been company charters before this. There were also, in Virginia, martial laws. Yes, he said martial, as in military, as in lots of death penalties. Jamestown was run on a somewhat different model. The settlers were there for financial reasons, and they weren't behaving well. So they ended up being ruled according to martial law for quite some time. But it was this, the Mayflower Compact, that brought to the continent the constitutional tradition that had, in fact, developed in Great Britain. As a constitution, the Mayflower Compact bound the Puritan colonists to work for the common good and to abide by the laws which were enacted by the government that was thereby established. As a religious compact, which it also was, that document bound its people together as a people in the name of God. So we have then with the Puritans a very self-consciously religious community using all the forms of constitutional government with the purpose of founding a society that would be ruled according to law, but that had as a necessary witness and party to the contract, God. All right. Let us then fast forward a bit to the era of the American Revolution, in which the colonists were fighting for independence from Great Britain. We know that a constitution for these United States came out only after that revolution had been completed. But before the national constitution was drafted, there was another conflict. There were, in fact, many conflicts, but the one I'm thinking about is the one in Virginia. The newly independent state there was considering a law that would tax all Virginians in order to pay Anglican, and only Anglican, teachers of religion for the state. Now, in petitioning the Assembly to reject this legislation, James Madison, who some of you may know as the father of the Constitution, laid out his reasons for opposing this law, for delivering this memorial and remand form and are born into, and in which they live the bulk of their lives. I want to just briefly mention one of the many issues that Professor Fornieri mentioned at the beginning during his introduction. He talked about the Declaration of Independence, which I know he considers foundational and of extreme importance, that document makes of the deity, in contrast to the lack of such mentions in the United States federal Constitution. And I think it is, in fact, a highly interesting and useful contrast to draw. And it points out something that I think is far too often overlooked in discussions of our Constitution more generally, but in particular in relation to things like religious freedom. Namely, that there was a distinction which the founders of our country recognized, which for a variety of reasons, is no longer generally recognized between those 13 independent states declared independent by that first document, which were seen as natural, organic, historically rooted focuses of attention and loyalty in which people lived, and the more distant, more artificial, more mechanical, hence more limited governments at the federal level, which was intended from its beginning to have a much smaller impact on the lives that Americans would lead. Now, in discussing this set of issues, I'd like to go back to the beginning, or at least as close to the beginning as makes sense in the American context. So, in the name of God, amen. No, I'm not about to give you a sermon. I may be accused of preaching, particularly by my children, but that's not my purpose here. That is, in fact, a quotation. It is the beginning of the beginning in some ways, because it is the opening line for the Mayflower Compact. The first line of the first constitutional document applied to the English settlers in North America. In fact, the Mayflower Compact carried on a long tradition, going back some 100 years in the mother country, where the Calvinist dissenters forged church covenants, they were called. Later they became constitutional documents, in which they would pledge to one another to walk in the ways of their Lord together, in order to form communities that could survive the intolerance of the Anglican establishment in Britain. They forged these communities by which they would elect their own ministers, by which they would regulate their own conduct among one another in religion, but also in economics and in social life, so that they could flourish as a group, worshiping God in the way that they chose, but also leading the kinds of lives that they wanted to, and flourishing as a community. That document, the Mayflower Compact, by which the Puritans formed a colony in the
unifying experience of the Great Awakening prepared Americans for the Revolution. Yet America was also profoundly influenced by a more secular strand of Enlightenment rationalism. Jefferson, for example, was a severe critic of sectarianism, of religious bigotry, and intolerance. He and James Madison famously led the fight to disestablish the Episcopal Church in Virginia and to defeat attacks for the non-denominational support of religion. Jefferson, of course, in his famous letter to the Danbury Baptists, describes the Constitution as erecting a wall of separation between church and state. While the Declaration, the foundation of the American experiment, I would argue, makes 4 references to the divinity, the Constitution never mentions God or religion except in prohibiting religious tests. Then again, the Bill of Rights, first 10 amendments to the Constitution, includes religion as its first freedom, the first freedom of the First Amendment. There are 2 notable clauses that relate to religious liberty that we will discuss tonight: the Non-Establishment Clause and the Free Exercise Clause. Indeed, there's a tension between these 2 provisions. Perhaps this tension has been vital to American liberty, one could make the argument. If construed broadly, the Non-Establishment Clause, in banning religion from the public square, might infringe upon the free exercise guarantee and vice versa. That is to say, the granting of an exemption for the sake of conscience, the free exercise of religion, may in effect constitute the preference of one religion over another, thereby undermining the very equality that the Establishment Clause promises to uphold. Interestingly enough, the same Congress that passed the First Amendment also approved of Washington's request for a national day of prayer and thanksgiving. So we gather here tonight on Constitution Day to reflect upon the legacy of religious liberty, the first liberty of our Bill of Rights. Our keynote, Bruce Fronin, will provide a historical overview of the struggle for religious liberty in America and a consideration of some of the core principles of religious liberty. After his presentation, we will analyze briefly the Supreme Court's application, or lack thereof, of these principles in two recent cases, Burwell versus Hobby Lobby and the town of Greece versus Galloway, a case right from our own backyard. We will conclude with a question and answer session, so please hold all your questions to the end, and the panelists will do their best to answer them. In the 21st century, our century, religious bigotry, intolerance, and persecution have far from vanished. Consider the recent genocide campaign against Middle Eastern Christians, the resurgence of anti-Semitism in Europe, and the sectarian strife between Sunni and Shiite Muslims. America remains a haven. America remains a haven. And can America still be considered the land of the free in this regard? Are the Constitution and the Bill of Rights fitted for an increasingly multicultural and secular nation? Now I'd like to introduce our keynote speaker. Dr. Bruce Fronin has served as a visiting scholar with the Johns Hopkins School of Advanced International